Good morning. My name is Kelly Weston. I'm an attorney in Atlanta, Georgia, and I'm speaking today on behalf of the Pro Bono Partnership of Atlanta. My topic is immigration compliance for business, and hopefully we will be able to focus a little bit on the nonprofit sector. Um, First, we would like to say thank you to the Georgia Legal Services for providing us with a platform to present this for you today. I would also like to say that although I'm an attorney, I'm not providing any specific legal advice. I'm just speaking generally on topics and providing general information to you. Just a little bit about the Pro Bono Partnership of Atlanta. Its mission is to maximize the impact of pro bono engagements by connecting a network of attorneys with nonprofits in need of free business legal services. If you would like to know more about Pro Bono Partnership with Atlanta and how or whether your organization might qualify, the eligibility requirements are on slide 3 of this presentation.
It's
Again, the.
hold on one second. It's not recording.
Are you kidding?
It's okay.
You're having the same issue where you were before with the box. Do you want my computer coming in?
With the box, with the website archive box coming up?
With it saying that it's the scheduled webcast.
In November, we had
It's
some
10 to
issues.
12. Okay.
Is this a computer? Do you want my computer?
Yeah,
Will that help?
I'm just,
Good morning. My name is Kelly Weston. I'm an attorney in Atlanta, Georgia, and I will be speaking this morning on the topic of immigration compliance for business. I'm providing this presentation on behalf of the Pro Bono Partnership of Atlanta, and just to let you know, the mission statement of the Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. To find out more about the Pro Bono Partnership of Atlanta and whether your business is eligible, the eligibility information you can find on slide 3 of this presentation. Would also like to start by thanking Georgia Legal Services for providing a platform for this webcast this morning. Also, although I am an attorney, I'm not providing legal advice today. I'm just providing some general information on topics of interest. So let's begin. The first topic I wanted to address is the E-Verify system. E-Verify is an internet-based system by the federal government, and the purpose is to allow employers to confirm the legal status and work authorization of the E-Verify system accepts the same information and many states have now started implementing their own regulations requiring certain to utilize the E-Verify system. Really just will allow the states about who needs to use E-Verify. The federal law on E-Verify requires federal contractors to states are now implementing their own laws on E-Verify. Indiana Another example, require government and their contractors to use E-Verify. These state laws are also in many cases making document fraud a crime. Georgia last year passed its own law requiring certain employers to utilize E-Verify. As of January 1st of this year, that ultimately any employer with 11 employees or more will have to use E-Verify. You are required by law to utilize E-Verify in Georgia. Not be able to get a license from the school of your license to prove that you are in fact enrolled in the E-Verify program. And as with many other state laws, for individuals to use fraudulent documents to obtain employment. So as I mentioned, January 1 was when this portion of the new that is for employers with 500 or more employees. For employers with 100 or more employees, they have to begin using E-Verify in Georgia first. And for employers with more than 10 employees, it's July 1st. The new Georgia law also had several other provisions other than provisions. The law enforcement provision gives officers the right to check the immigration status of a criminal suspect. The officer has probable cause to believe that the individual has committed a crime and to produce a valid identification document at that time. The legislature passed this provision of the law. It was challenged legally. The arguments on the matter are more at that time or shortly after that time about another section of the Georgia law that was relates to transporting undocumented aliens. Fine to knowingly transport an undocumented immigrant by motor vehicle again, very important, this provision of the law is also currently on hold because of legal proceedings to enjoin it. Again, up for argument before the Appellate Court of Georgia at the end of February. Another section of the Georgia law relates to harboring. This is also a provision that is currently on hold, and we will know more about it in a few months. But as written, the Georgia law makes it a crime to knowingly conceal, harbor, or shield an undocumented alien with knowledge of their undocumented status. Again, there has to be another crime in process for the Georgia law to make this harboring a separate crime in and of itself. I hope that makes sense. And again, there are exceptions for the provision of social services, for providing emergency medical care, and also for attorneys providing legal advice in criminal proceedings. And also, I'm sorry, one more exception for persons providing services to infants, children, and victims of crime. So, although these are the regulations or the law that has been passed by the Georgia legislature, we don't actually know what the law will ultimately be until we hear from the court whether it's even legal for Georgia to pass these laws. If they do, it'll be something similar to this, but not exactly the same, so you should probably keep an eye out for that. I wanted to move on to another topic. I had mentioned E-Verify quite a lot, and in conjunction with that, I talked about Form I-9s. Some of you might not know what a Form I-9 is. It is a federal form. It's required for every person you hire. All employers have to use an I-9 to verify the identity and the work authorization status of every new hire in their organization. You can go online to uscis.gov and get free access to I-9 forms. If anybody tries to charge you for an I-9 form, you don't need to do that. They're available for free. The August 7, 2009 edition of the form is the current edition. It's very important that you use the current edition. You can also find online a handbook for employers. I've given you a web link. And this is a handbook, again, put out by the federal government that provides a lot of information about the form and how to complete the form, and it gives you pictures of documents. And it's extremely helpful. And there is also now at uscis.gov an I-9 Central web link, which will also provide you a lot of information about I-9s. To discuss the I-9 process, the I-9 has to be completed within 3 days of employment. That means when you hire someone, you can complete the I-9 at the time of hire or within 3 days of them actually beginning working for you, but no later than that. Even if you hire someone for less than 3 days, you still have to complete an I-9 for that person. If an individual presents a receipt for a document needed by the employer to verify the information on the I-9, they have 90 days to produce the actual document. When you look at the I-9, there is a requirement that the employer actually review certain documents for the individual. There's a List A document, which would be, for example, a passport, which proves the person is who they say they are. There's a picture. and it also proves that they're eligible to work in the United States. There's a list of documents on the I-9 form itself that you can use. Other documents would be a List B and a List C document. One proves only identity and the other proves only work authorization. When you sit down with the employee and ask them to produce documents for the I-9, the individual has the right to choose which documents they're going to present. You cannot, for example, say, you need to show me your driver's license and a social security card. What you could do is give them the list of documents and say, you need to present me with, documents from this list that satisfy the I-9 requirements. It's actually a crime to require a specific document or to require more documents than those that establish identity and work authorization. When the employer reviews these documents, they can make copies of the documents. For example, a driver's license and social security card. You're not required to make copies, but it actually is, I think, a very good idea. It's, as I said, very important to complete the I-9 properly. You can be fined if there is an audit of your I-9s by a federal government agency, up to $1,100 per I-9 violation. So if you have 10 employees and you've messed up all 10 I-9s, that can be a lot of fines. Make sure the I-9 is properly dated. Make sure it's signed by both the employee and the employer. Use the proper version of the form. Again, don't specify which documents can be accepted. Also, under the newest provisions of the law, you cannot accept expired documents at the time of completing the I-9 form. So if they hand you a driver's license and it's expired, you can't actually accept that. If the document expires later, in most cases, that's okay. In other cases, if the document expires, you have to go back and re-verify, but we're going to talk about that in a minute. In accepting documents, if the document looks valid and it looks like the person that is presenting it to you, you accept it. You don't have to play detective and, hold it up to the light and see if the watermark is right. If it looks correct, accept it. But, if they hand you a document and, it's just doesn't even look like the person, then you can question the document. You are required to retain all I-9s and make them available for inspection if the government comes calling. And if you do choose to make copies of the documents, you need to keep those with the I-9s as well. So just when is a document not acceptable? As I mentioned, if it's an expired document, you can't accept it. If it clearly is not a valid document, you cannot accept it. We've given you a couple of examples. If, the social security card, the eagle is upside down on the card, that's clearly not valid. If it's all crooked on the page, that's not valid. If the photograph is of a woman and, it's a man presenting it to you, clearly you can reject that document. But if it's not obvious, you should, in most cases, go ahead and accept the document. If you do need to reject the document, the proper procedure is to inform the worker that you cannot accept that document because, this really does not look like you at all, or, this document does not look right. Give them the chance to present another document. And if they cannot do that, it's really only at that point, after kind of giving them a second chance, that you should, in most cases, sever the relationship. Again, every situation is different, and I can't sit here and tell you what to do in every situation, but just generally speaking. And usually you should let the person know what the reason is for letting them go. And we talked about not accepting expired documents when you complete the I-9. But if a driver's license, for example, expires after the person's been, with you for a couple of years, that's fine. But some documents, when they expire, you actually have to go back to the individual and re-verify that they are still eligible for employment. In most cases, this is going to be a strictly a work authorization document, either an employment authorization card or maybe a stamp and a passport. Those are the only times that you need to re-verify. And I'm sorry, I'm on slide 19 for everybody who might have gotten behind. So you don't re-verify identity documents, and you don't re-verify documents that show someone has permanent work authorization. What does that mean? For example, a green card, new green cards all have expiration dates. But a person who has a green card is going to be employment authorized forever. You never have to re-verify a green card. So again, it's really only the employment authorization documents. And when you look at the Form I-9, you'll see on the very bottom, there is a section that is set aside for the re-verification. And you just put the information in there and sign it and date it, and you're good. And then the final thing I wanted to talk about Form I-9s are the retention requirements. As I said, they have to be maintained for all active employees. You also have to maintain the I-9s after employees leave your employ. You have to keep them for the longer of 3 years from the date of hire or 1 year after the date of termination, whichever is longer. And I know that's confusing, but a simple way to think of it is if you hire a person or the person works for you for a year, you have to keep the I-9s for a total of 3 years. If they've been with you for 20 years, once they terminate, you're going to have to hold on to them for only another year. Again, confusing. It helps if you set up a system for reviewing your I-9s regularly. Moving on, another topic I wanted to address were Social Security no-match letters. These are letters issued by the Social Security Administration when the information in their database does not match the information the employer is submitting. And that is going to be the name of the person doesn't match the Social Security number. They will issue, if the Social Security Administration flags your company to send out these letters, they will issue one letter per employee that's in question. If you receive one of these letters, please don't ignore it. The first thing that you need to do is check the information on the Social Security letter against your records. Is there a simple transcription error? Has somebody, entering data just typed in a wrong number? That's a really easy situation to correct. If that's not the case, the next thing to do is go to the employee and inform them, we have received this letter. Can you confirm the information in this letter? If they inform you that the information in the letter is correct, then the advice actually that the Social Security Administration puts out is that you should advise the employee to contact the Social Security Administration to try to resolve the error, and you should provide a reasonable amount of time for the employee to do that. They don't tell you what's a reasonable amount of time, but 2 weeks is probably too short, and 4 months is probably too long. So, there's no real information on what's reasonable. But in any case, you do need to follow up with the employee. You give them a certain amount of time. You follow up with them and say, have you been to Social Security Administration? Is this issue resolved? Again, you can't demand they provide you any specific document, but you can generally require that they provide some document. You just can't tell them which one to demonstrate that the information that you have is correct. You should submit your corrections to the Social Security Administration, and it's important to note that if you do receive a Social Security Administration letter, that does not mean that the employee is undocumented or here illegally. It just means that there's an error in data. So just receiving the letter is certainly not a reason to terminate anyone. That would actually be a violation. If they are unable to resolve the issue, then that is something you have to consider at that point. Again, all the information that I've just given you is the actual process that the Social Security Administration recommends, and you can find information about that on their website. You need to retain for 4 years your documentation in relation to the Social Security no-match letters. And then briefly, I wanted to just touch on the issue of worksite enforcement. What I mean is a government agency or entity coming to the company either physically or through the mail or through some contact and questioning some aspect of your immigration compliance. This might involve issues or suspicions of employing undocumented workers. It might relate to suspicions that you are not keeping your records as you're supposed to, for example, the I-9 forms. Or it might relate to immigration-related discrimination or suspicion about that. And if you read the paper, I'm sure you're aware, the enforcement agencies of the government have been really busy in this area, and I mean there were over $43 million in fines issued in 2010 by the federal government relating to these kind of issues. And no one is immune, nonprofits included. So just some suggestions I generally give to try to avoid those kinds of fines or having the government show up at your doorstep. Generally, I call this a self-audit. What can you do to go and look at your policies and your paperwork to protect yourself as much as possible from these kinds of government intrusions? First, properly completing and holding on to your I-9 forms, including having in place some kind of system to let you know if you need to re-verify an I-9, that is, go to the employee and confirm whether they're still employment authorized. I suggest training the individual who is actually responsible for sitting down with new hires and going through the I-9 with them and reviewing the documents. And also having in place a way to let employees know in advance that, hey, in 4 months, we're going to have to come and recertify or re-verify your employment, just letting you know so you can go, if you haven't already, and get your paperwork in order with the government. Having in place policies relating to retaining and the destruction of I-9s after you don't have to hold on to them anymore. And then, properly storing them. For example, do you want to keep them in the personnel files of the employees, or do you want to keep them somewhere separately. So if the government wants to come in and look at your I-9s, you don't want to be scrambling through your employment files. Other items in a self-audit you're going to want to look at, if you are enrolled in E-Verify, are you in compliance with the agreements that you have to sign to enroll? They're called MOUs. Do you have procedures in place so that if Immigration and Customs Enforcement shows up at your door, does everybody know what to do? For example, does everybody know who's the first person to call? Does everybody know who is responsible for speaking with them? Just things like that. And then, sorry, there's something wrong with my presentation, but if you have contracts with subcontractors, are they doing what they need to be doing to comply with immigration laws? On slide 25, I just come back to the point. There are several government agencies right now policing I-9s that is looking into whether they are being properly completed and maintained. So compliance is extremely important. And the best defense, yes?
Who are those agencies?
Okay. OSC is the Office of Special Counsel. That is part of the Department of Justice, and they look at the kind of discrimination aspects of I-9s. Are you requiring too many documents from, people with Hispanic last names, for example? While ICE is Immigration and Customs Enforcement, and they're much more concerned with undocumented workers. In both of these cases, your best defense, if the government does show up, even if you have made some mistakes and have technically violated some laws, if you have tried in good faith to comply with the laws and are not knowingly doing something wrong, that's your best defense. So if you have a really good system in place, to make sure everybody completes their I-9 in a timely fashion, and you do some training and you maintain your records right, even if you've committed some violations, you're going to have much, much lower fines. You wouldn't be facing any kind of criminal penalties or prosecutions. So all of this that I've spoken about with the self-auditing and knowing how to complete the I-9s is, really, really important. If there is a worksite enforcement action, and here I'm talking about Immigration and Customs Enforcement raids, the effects of that, of course there's fines and penalties, but there's also the potential for criminal prosecutions, and if you have a problem with undocumented workers, you're going to lose half your workforce overnight. How do you deal with that? You also are going to have a publicity problem and client relation problem. And you might also have some increased expectations going forward from the people that you contract with. They know you've got this immigration violation and you've had this ICE raid and this problem, and they might be expecting some additional security or confirmation on your part that you're going to comply with the rules going forward. So how do you prevent this? I've mentioned most of these things already. Train your people on completing I-9s, establish good hiring practices. Everything that you do needs to be applied evenly across the board. Establish protocols for responding to the government, whether they show up in person or call on the phone or you receive a letter. Everyone needs to know how you handle that. And you can consider whether you want to voluntarily enroll in the E-Verify system. You might not be required either by Georgia law or federal law at the moment, but you can voluntarily enroll. Some people do that. Some people don't think it's a great idea, but it's something to consider. The trend in the law right now, certainly at the state level, is more and more immigration-related laws, more compliance obligation being pushed onto employers. The federal government has initiated more arrests and detentions than ever in the last couple of years. Foreign business people traveling to the United States are having a harder and harder time getting visas to actually come here. And as I mentioned, a lot of the burden of enforcing the immigration policies are being placed on employers, and that's really going to increase in the future. So it's just something that everybody needs to be aware of and keep abreast of the laws on. Now, time for questions. No questions. Is anybody listening? Okay. Well, I hope that means that I've explained everything well, and I want to, thank you all for listening, and thank you, Pro Bono Partnership of Atlanta, for letting me speak.